Deputy Registrar, would you please open the proceedings?
Good afternoon, Judge. Thank you. Caribbean Court of Justice, original jurisdiction, judgment delivery in AGOJ number 1 of 2021 between Ellis Richards, Medical Benefits Board, Spencer Thomas and others, and the state of Trinidad and Tobago. The members of the delivery panel are Mr. Justice Anderson, presiding judge.
Good afternoon, Counsel.
Madam Justice Rajnath.
Good afternoon, everyone.
And Mr. Justice Burgess.
Good afternoon, everyone. I apologize. It appears as though I'm having some technical difficulties with my video, but I can assure you that this is me.
May we have the appearances, please? Thank you.
On behalf of the claimants, I continue to lead the team of Dr. Kenny Anthony, Mr. Rob Strang, Mr. Greg Pantin, Professor Matthew Happold, Mr. George Kernan, and Mr. Miguel Vasquez. And could I just note that somehow Professor Matthew Happold has dropped off the list of those names that should be contained in the draft, in the judgment, and was present at the last hearing. And instead, I would ask you to remove Mr. Rafael Hadjodia, who did not participate in the last hearing and does not participate any longer on behalf of the claimants. Thank you, Your Honours.
Your Honour, should it please you, Mrs. Deborah Peake leads me tomorrow Tulsi for the state of Trinidad and Tobago. We are instructed by Mr. Brem James and Mr. Murvani Oja Maraj.
Thank you, Counsel. Are there any other appearances?
No, Judge, there will be no more.
Thank you. Well, thank you again, Counsel, and thank you all. First, I must apologize for the absence of our President, Honorable Mr. Justice Adrian Saunders. Justice Saunders is outside of the jurisdiction, I should say far outside of the jurisdiction. He's on official business and therefore is unavoidably absent from today's proceedings. He sends his apologies. Unfortunately, Justice Jamadar is also not available for this sitting. The judgment, however, that you have received advanced copies of is the judgment of the entire bench, signed by all the members of the bench, including President Saunders and Justice Jamadar. I know, of course, that you have received advanced copies, and I know, Mr. Davenport, that you, in particular, I think your side, wish to make some comments in relation to that document. We could hear you very briefly because I think we have a solution for you, but just very briefly. Thank you.
Thank you. Now, would it be convenient to hear me now?
Yes.
Thank you very much indeed. Well, I'll keep it short and sweet. The simplest issue is the preliminary issues which you were determining by this judgment didn't actually cover Article 8184 at all. That was made very clear, and that was made clear in the judgment itself. I could give you other quotes from other documents, including Senior Counsel Peake's address to the court. It didn't form any part of her submissions. The claim, I've been through it carefully, very much does survive, and essentially the same central claims survive, and it leads to the same loss. And many of the other declarations, all but two that we claim in the relief section, would still survive. The simple point is that we retain our argument based on Article 184 coupled with Article 7. Neither Article 184 or Article 7 are within Chapter 3, of course, and you were determining the effect of and the true meaning in these circumstances of Article 30. I won't set out what Article 184 sets, because you know it very well indeed, or indeed Article 7 in Chapter 1, which are the core principles. But essentially, that survives. The rescue plan, in many ways, constituted a measure to provide redress to consumers, and the meaning of Article 184 of the treaty applies. And the claimants receive very different treatment, is the case from the defendant in comparison to policyholders of BA Trinidad, and that differentiation that they received is very much maintained. It was actually well summarized by Senior Counsel Peake in her written document to you after the hearing, where she says, for the purpose of determining the preliminary issues, we're not looking at the claim under Article 184, etc., which does not fall within Chapter 3, and in particular Article 30. She, in her oral address, so far as the transcript that we had,
Mr. Peake, sorry, Mr. Davenport, I'm so sorry, very sorry.
Yeah, you've got the point.
I think, yes, I think we are with you. I don't think there's any difficulty in saying that the claim under 184(1)J survives the judgment of this court. I thought your concern had to do with the reach of our judgment in relation to Article 7.
It does. It
yes.
Really said that 184 basically it lives with Article 7. It's not the end of Article 7 debate. I think I put it as a clarification, no more than that. I'm sure yes. You all saw it that way. It was simply that insofar as Articles 36, 37 and 38 were concerned, that interrelationship with Chapter 3 can no longer stand. Yes. And Article 7 goes in respect of it. But in respect of 184, there is a separate existence to Article 7, and I'm sure you saw it that way. I just wanted to try and clarify.
Yes. Any comments, Mrs. Peake?
John, I have to say, when we looked at the pleading, it appeared to us that the Article 7 point was linked to Chapter 3. But I do understand my learned friend is now saying that, in fact, you have to read the pleading so that Article 7 is distinguished from the claim under Article 3 and ought to be read together with 184(1)G. So if that is the position that they've now clarified, it's entirely a matter for the court.
Yes. And I must say that in the deliberations and in the drafting of this judgment, we were concerned with the reach of Article 7 only as regards the claims under Chapter 3. So we thought that that was pretty clear from the judgment we gave, but just to make doubly sure, we have added a few words to the judgment that will make very, very clear that to the extent Article 7 is applicable, then it may be pursued in relation to the claim under Article 184(1)J.
Very grateful.
Thank you. So with that being said, I will now read a summary of the judgment. The usual reminder, of course, is that the judgment is the only authoritative statement of the opinion of the court, and the summary ought not to be used as a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. After the collapse of the Trinidad and Tobago conglomerate, CLF, or CL Financial, CLF, in early 2009, the government of the state of Trinidad and Tobago, the defendant, decided to rescue or bail out the company and its Trinidad and Tobago subsidiaries, Clico Investment Bank, CIB, Colonial Life Insurance Company, Trinidad Limited, Clico, and British American Insurance Company, Trinidad Limited, BAT. The defendant engaged in a series of measures including the assumption of control of CLECO and BAT, provision of liquidity support, injection of funds, and the purchase of the rights of some policyholders of CLECO and BAT in order to mitigate the effects of the collapse on the policyholders and the wider Trinidad and Tobago economy. The claimants, nationals of and institutions established in Antigua and Barbuda and Grenada, were all policyholders of another CLF subsidiary, British American Insurance Company Limited, BICO, which was incorporated in the Bahamas. They alleged that when the defendant carried out the bailout measures to rescue CLF and CLECO, CIB, and BAT, the same protection was not offered to them as policyholders of BICO. They argued that the defendant, through its central bank, took active steps to exclude them from the scope of its rescue of CLF and took steps to positively disadvantage them when compared to the steps taken in relation to the policyholders of BAT. They claimed that these actions amounted to discrimination on the grounds of nationality in breach of Article 7 of the Revised Treaty of Chaguaramas, the RTC. They further claimed that the defendant's intervention came within the scope of the application of the RTC because it concerned cross-border provision of services under Article 36 and a measure taken by a member state to provide redress for consumers within the scope of Article 184(1)J. In its defense, the defendant contended that the facts and matters of the claimant's claims fell out with the RTC and thus the jurisdiction of the court. The claimants had invoked Articles 36, 37, and 38 of the RTC, which fell within Chapter 3 of the RTC, and Article 184(1)J. Article 30, which defines the scope of application of Chapter 3, excludes from the operation of Chapter 3 activities in a member state involving the exercise of governmental authority. At the case management stage, the issue as to whether the activities fell within Article 38(2) arose, and the court directed the parties to make submissions on two preliminary issues. First, assuming for the sake of argument the truth of the matters pleaded by the claimants in the originating application, do the actions of the state of Trinidad and Tobago alleged by the claimants fall outside the scope of Article 3 of the Revised Treaty of Chaguaramas because they fall within the meaning of Article 32 and Article 33. And second, if the answer is yes, what are the consequences for these proceedings? In examining the purpose and objectives of Chapter 3 of the RTC, the court explained that the chapter addressed 4 fundamental freedoms or rights that help to form the core of the CARICOM single market and economy, namely the right of establishment, the right to provide services, the freedom to move capital, and the freedom of movement of community nationals. Notably, the obligations imposed by and the correlative rights accrued from Chapter 3 are among the most critical elements that advance the objective and purpose of the RTC. The court considered that under these areas, the member states have agreed to yield aspects of their sovereignty for the collective good. However, the inclusion of Article 30 in the RTC makes it clear that a space is reserved for member states to permit them to conduct activities which are excluded from the scope of operation of Chapter 3. These excluded activities are exempted from the restraints and constraints imposed upon member states by the chapter. Furthermore, the non-discrimination rule in Article 7 applies only within the scope of application of this treaty. In these circumstances, the court can and must make the appropriate declarations. Where a dispute arises as to whether a governmental activity falls within or outside the excluded zone, Article 32 and Article 33, the court must consider the facts of the case, including the nature of the activity in question and the general context in which the activity was conducted. In the present proceedings, the court considered the wording of Article 32 and 33 to determine whether the nature of the defendant's activities were activities conducted on a commercial basis or in competition with one or more economic enterprises, and or whether they fell within the definition of other activities conducted by a public entity for the account of or the guarantee or using financial resources of the government, Article 33, subparagraph D. The court considered that the defendant's actions as presented in the claimant's pleadings were not commercial in nature. There was no suggestion that either the government of Trinidad and Tobago, the Ministry of Finance, or the Central Bank of Trinidad and Tobago, when making the relevant decisions, assuming control of CLICO and BAT, and taking control of CLF's assets in exchange for the liquidity support, were doing so on a profit-making basis, or for the purpose of participating and seeking superiority or supremacy in the single market alongside or against economic enterprises within the defendant or within the other member states. The activities involved inter alia, legal, accounting, and managerial intervention by the central bank and the direct use of financial resources of the defendant to mitigate the effects of the financial collapse of CLF. The pleadings clearly suggested that the defendant's activities in providing liquidity support to CLICO and BAT and in purchasing the rights of their policyholders involved the use of state funds and fell expressly within the terms of Article 33, subparagraph D. The court therefore agreed that on the facts pleaded by the claimants, the defendant's actions were to be considered activities in a member state involving the exercise of governmental authority conducted neither on a commercial basis nor in competition with one or more enterprises, as defined in Article 32 and 33, and that those actions fell outside the scope of application of Chapter 3 of the RTC and therefore outside the ambit of Article 7. Accordingly, the court ordered that the claimant's claims with respect to breaches of Articles 36, 37, 38, and 7, insofar as it relates to Chapter 3, be dismissed. The claim with respect to a breach of Article 184(1)J and Article 7, insofar as it is applicable, may proceed. The court reserved the issue of costs to the conclusion of the matter. That then is the summary of the judgment of the court. There is, of course, the further issue as to the prosecution of the claim that has survived this judgment. The feeling of the court is that we should consider an early CMC to see how that claim may be further litigated. And if both sides are agreed, the court was thinking of an early date such as the 21st of March, possibly.
I'd certainly agree on behalf of the claimants and was going to propose the same. And the 21st of March is a good date for me. I can't speak for everybody else all in one go, but for me, that's a good date.
When you say for everybody else, you mean
on my team?
Everybody's on the other side, but on your team.
And I certainly can't speak for Ms. Peake and Ms.
But on your team, the 21st is fine.
Fine.
Thank you so
yes,
much.
I don't know all the dates of the others, but for me, it's good. I'm hoping that most of the team will be able to make that.
Thank you, sir.
Your Honor, that date is convenient to the defendant.
Okay. Shall we say 10 a.m., please?
Yes, that is convenient.
Thank you, ma'am.
Could I make a suggestion to try and make things move along as quickly as possible? I don't expect you to remember it, Your Honour, but at the time of the ordering of the preliminary issue, there were contentions by both sides as to the further conduct of the claim, and there was a draft order that was being circulated. Can I suggest that you direct, if necessary, or at least opine that the party shall do their best to try and narrow the issues and agree what should constitute the directions for the further prosecution of this matter, and exchange their views accordingly with each other in time.
Mrs. Peake?
We would have no difficulty in hearing what the claimant's proposals might be, and then we would be in a position to comment on same and see whether we're able to agree anything to submit to the court.
Yes, I think that might be a better way to proceed, Mr. Davenport. We don't want to order that matter at this point, but as Mrs. Peake suggests, she has an open door, and I'm sure you could make contact and see whether there's a possibility of narrowing down the issues to be pursued.
I'm grateful.
So shall we leave it there?
Yes.
Much obliged.
Thank you very much. If there is no nothing further, Madam Deputy Registrar, would you bring the proceedings to an end?
Yes, please, Judge. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Washington. Thank you, Mr. Justice Burgess. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you.